I want to welcome everyone to the April 21st, 2021 CS BARS meeting. Before we get started with roll call, I just want to go over a couple of items that are going to be adjusted slightly on the agenda. We are going to cover the agenda as organized online, and you have access to the agenda online, except for one item which will be switched, and that is we will take item G, the NPR conversation, before item F, the guideline conversation. If we have sufficient time, we will continue our guideline discussion. Those proposed guidelines that we've been discussing since January will be made available to the public and added to this agenda as well as past agendas soon, and we won't be taking any action on those items until at the very earliest our next meeting, and that will occur after the CBE decision on sending the rules to the board, and then the May board meeting regarding the rules as well. So just wanted to give people a heads up about that. I also wanted to give you some information about public comment. We'll take public comment after our roll call on all items on the agenda except for item G, which is the NPR discussion, to really enhance the public comment for that, as well as to give the committee the opportunity to hear from the public about the presentation. We're going to have the staff do a presentation about the various options available regarding the NPR. After that, we'll ask for public comments specifically on that item, and then we'll have a committee discussion about that item. So when I call for public comment, it will be about every item on the agenda except for item G, and then any other public comments that might be warranted at this time as well. We're going to limit public comment to 2 minutes, and at both the beginning as well as during that other portion. I believe that we also have 2 guests coming, one hopefully at 1:15, another at 1:30, which should occur during the staff presentation. But if we start our other portion of the agenda, we'll stop that agenda item in order to hear from our special guests, and then we'll continue with the agenda as posted. So at this point in time, I would welcome Ashley Cohn to take roll.
Thank you, Dean Gardina. Dean Clancy.
Present.
Dean Frickberg.
Present.
Mr. Kramer.
Present.
Mr. Murphy.
Present.
Dean Park.
Present.
Dean Pritikin.
Here.
Dean Gardina.
Here.
We have quorum.
All right, thank you. And now is the time for public comment on any item or other areas of interest to the public on the agenda, except for item G. As I stated earlier, we're going to reserve comment on that item until after the staff presentation, and that limited to the 2 minutes at this point. So I welcome any members of the public who would like to offer public comment at this time. All right. Doesn't appear as if there's any public comment at this time, and so we'll continue with our agenda. Next up is approval of the minutes from the March 2021 meeting, and I would ask if everyone had a chance to review the minutes as they were posted as part of the agenda. Are there any corrections or other discussion related to that? If not, they'll be approved as posted. Okay.
I'm happy to move to approve the minutes.
Thank you. So Dean Park moves to approve. Do I have a second?
I'll second.
Second, and then Ashley, would you like to take roll call on that?
Yes, thank you. Dean Clancy.
Aye.
Dean Frickberg.
Aye.
Mr. Kramer,
Sorry, aye.
Mr. Murphy,
Aye.
Dean Park,
Aye.
Dean Pritikin,
Aye.
Dean Gardina.
Yes,
The motion passes.
thank you, Ashley. So next up is the staff report.
Thank you, Dean Gardina. We will be having several guests today. And because David Lane, our guest related to moral character, is here, I would suggest that we begin with him and then we'll proceed with Mr. McPhail and the oath ceremonies subsequent.
Thank you. Thank you, Mr. Lane.
Sure. Thank you for having me. I'm happy to be here. I'm David Lane. I am the attorney for the Moral Character Unit at the State Bar. And I have a few items to pass along, not a whole lot of news. The first is that it would be helpful if folks could advise students to update, just remind them to update their email before they graduate. We get people who still have their law school email address, and then at some point it becomes defunct and it's in our system. So they should update their email address in the student portal. Another thing that we see not infrequently are students who neglect to update their law school applications with respect to some event that might have happened during law school. And oftentimes, I know that when I've talked to students who this has happened to, they say, I think they told us during orientation that we had a duty to update it, but I don't remember. Anyway, it would be great if maybe that could be mentioned, that obligation. I don't know if it could be an email blast or some other school-wide event, maybe in the 2L year, 3L year, to remind folks of that. That would be helpful. Frankly, that one's for it would be great for the students. It would save them, because then by the time they get to us, it slows them down. It slows down the application. One thing I wanted to mention on the technical side, so the new system we've been using now for a little while is working very well. And sometimes it works too well. Apparently, some schools have been getting two law school declaration questionnaires for a single applicant. We apologize. It could be because the applicant put the school twice in the application. Sometimes you can't remove things from certain fields or go back. We've all been there in different contexts. The bottom line is that when they submit the application, those questionnaires automatically get sent. And so if they're duplicate email addresses, it'll get sent twice. Please feel free to disregard any more than one. If you respond to one, that's all we need. And these are the kind of things we'll try to address as we find them. And that is about it for me. If anybody has any questions, I am happy to answer them.
I have one.
Sure.
David, you talked about updating the applications. Are you talking about updating regarding information or events that should have been disclosed on the initial application for enrollment, or updating as to intervening events? And I ask because we have had students who have all of a sudden submitted information that they should have put on their initial application for enrollment, but they've done it 2 to 3 years late. And of course, that's a problem for them. But I'm just wondering what you mean when you talk about updates.
No, I appreciate you bringing up the point. I was referring to intervening events that might happen during law school, but of course you are 100% correct. And we see that just perhaps as frequently, where suddenly somebody remembers, the 3 DUIs that they got the year before law school when they're about to graduate. Or something, or I shouldn't, sometimes people truly forget to disclose something, then they're going through the moral character process and they realize, and they go back to their law school. So in this case, I happen to be referring to intervening, but the same thing applies, anytime were I a school, anytime I told students, you have a continuing duty to update your law school application, I would say, and by the way, that includes updating it with respect to information that you omitted that you should have included in the first place. Yeah, I appreciate you bringing up that point. We see plenty of that.
Thank you for the answer.
And if there are no other questions, that's it for me. Again, I'm David Lane. I'm the attorney for the Moral Character Unit. Please feel free to reach out if you ever have any questions. If I can be of any assistance, I like to feel useful. So thank you, and it's good to see you all.
Thank you, Mr. Lane. And it appears as if Mr. McPhail is with us as well to talk about the attorney oath.
Good afternoon. I'm going to share my screen. So you should be able to see my screen. My name is Robert McPhail. I'm a manager in the Attorney Regulation and Consumer Resources Department, and we wanted to talk to you today a little bit about the oath portion of the admissions process for attorneys, some information that you can share with your students, which will help streamline that process, and also if you as law schools do oath ceremonies, I'll talk very briefly about that. I am a manager in the department that handles pretty much all of the regulatory aspects of being an attorney, like MCLE. We do the customer service for your fees, and we also are the folks that admit attorneys and maintain the role of California attorneys. So I wanted to start just briefly by talking about kind of licensing from our perspective. And so in order to, to be clear on this, the Supreme Court orders attorneys who have met all the requirements for admission to be eligible for licensure. Once that has happened, they will have an admission date, which is determined by the date they take an oath of office. And the actual physical act of having a bar number created and being set up as an attorney requires submission of what is known as a registration card or oath card. The way the process works from your student's perspective is once they are eligible for admission, which includes all of the things, including passage of the bar exam, they get we call it a results packet, but they get a packet of information that includes a paper oath card and instructions on how they need to join the bar. So part of that requirement is an oath, and we're having this because some situations have arisen this year, and I'm mainly going to be concentrating on this so that you can work with your students so that they understand how to streamline the process of getting set up as an attorney. Attorneys can take their oath in two ways. Most attorneys swear in individually. Once they get their results packet with their oath card, the easiest way is to go to any notary, but there's also on our website a list of eligible officials like judges that can administer oaths. In this time of COVID, be aware that most states do not allow their notaries to do remote swearing in, and that also applies to the state of California. So for most states, for a notary right now, they are going to have to go there in person with themselves and their oath card. The other thing, and I don't know how many of the accredited law schools do this, but there are law schools that conduct oath ceremonies, either in person or virtually, where the school finds an eligible official who conducts the ceremony, collects registration cards, gets them signed and back to us. So that's kind of how the oath works, which is very key to the process of admissions. A couple very important takeaways that for both you and to share with your students that are really important. In order to take a valid oath of office, you have to have been certified for admission, which means the Supreme Court has you on the order that makes people eligible to become lawyers. If someone tries to take their oath before that, that is not going to be accepted by us. And this creates a situation where we have to work with them to resolve the situation. So your students need to be aware they cannot take the oath until they receive that results packet with an oath card. Passage of the bar exam does not make you eligible. It's the rest of the admission steps and having the Supreme Court put an attorney, prospective attorney on that order. The other very important situation that is coming up now more because of COVID is you take the oath, an attorney takes the oath and signs and dates the back of the registration below the oath, and then the administering officer, notary, judge, whoever it is, also signs and dates it. That date is the date the oath was administered. So in the world of virtual ceremonies and some things being done virtually, it is not the date if it's, you know, a card that's mailed into a judge after a virtual ceremony. It is not that date. It is the date that the oath was actually administered, and the two must match. And this situation has arisen more in a virtual world this year. The oath card for the next round of results has been changed to try to clarify this further. And we are also, we have lots of information on our website, and we're currently going through it and updating it to provide more information on this and other issues. I thought I would share some of the other registration card mistakes to avoid. Feel free to share this with your students. These may sound simple, but they are going to create delays if they're not addressed. The cards are still in paper form and they're filled out by hand. They need to be legible. We're asking for required information. They need to be complete and they need to be signed and dated. This may sound silly, but this year we got a significant number of cards that just had a signature. And in some cases, the signature was so illegible, we had no idea who was trying to swear in. And finally, this is sort of a special circumstance, but if a prospective attorney has changed their name and they're wishing to be admitted under a new name, which is not the name that was shown on their results letter that was sent with their oath card and admissions information, they would need to submit a name change form along with that registration with the required documentation to change a name. Otherwise, again, we have to work with them to get that. And all of these mistakes can lead to a delay in getting admitted. I don't know how many of your schools do oath ceremonies, but just very, very briefly, a couple things to understand about oath ceremonies if you decide to conduct one, is you need to select an appropriate date. And this is also something that you should make your students aware of. It is included with registration materials, but fees are a separate matter from admission, but they are based, your first year's fees are based upon when you are admitted. So if you are admitted between January 1st and June 1st, you owe the full year's fees for that year. If you are admitted between June 1st and December 1st, you owe half a year's fees. And if you are admitted after December 1st for that year, you do not owe any attorney's fees. And so attorneys should be planning accordingly. And if you do an oath ceremony, you should plan accordingly so that they take their oath when it's appropriate for when they're going to be using their attorney license. The official administering oath should understand the date requirement that I talked about. I would be informing students to review their admissions packet. It's a very exciting time when you get a congratulations letter with an oath card, but there's a lot of very regulatory information in that packet that it is definitely worth reviewing, including instructions on how to take the oath and get admitted. One thing that happened with COVID is if you decide to do an oath ceremony for your students, we send out oath cards with an envelope with the state bar address on it, but it is a envelope that also has a barcode. It's set up for post offices to use automated mail handling. You cannot put a label on that and send it on to someone else. It's going to get delivered to the bar because of that barcode. And if possible, if you're doing an oath ceremony, work with your students, review those oath cards and make sure that they are accurate. I have a link here for the materials we have online. As I mentioned, those are being updated and enhanced right now and will be ready for the next results. And finally, I wanted to explain some student resources. Main thing is to share with your students that they're going to get an admissions packet, and they also get an email with links to all of this information. The first piece of information that is now going to be in that is our new registration card handout. This is a very small sample of it because it has an oath card specimen on it. But this they will have in the mail. This has step-by-step instructions for how you fill out the card. Doing this will streamline their admission to the state bar and avoid delays in getting a bar number and getting set up to practice law. We appreciate any help you can give us in communicating this to your students who are ready for admission to the bar. And I thank you for giving me the time to talk about this.
Thank you. And any questions from members of the committee? Okay. Mr. Fail, I just have one just to make sure I understand, because June 1st came up both in terms of when you owe the full fees and when you owe half fees. If I'm sworn in on June 1st, I will only owe for half of the year's fees. Is that correct?
It is equal to or greater than date. You are correct.
Okay, great, wonderful. Appreciate that clarification.
I don't have a question, but I want to say I think it's great that there's a student resources development there related to oath cards, especially for virtual ceremonies. That's been definitely requested with us at our school. So.
All right. Thank you both for coming and providing that information to us and to members of the public that are here today. Incredibly helpful. And I think, Natalie, we can move forward with the staff agenda.
Thanks and have a good day.
Nat, you're muted.
Sorry about that. At this point, I would like to welcome our Office Director, Amy Nunez, to discuss the Bar Strategies and Stories program.
All right, good afternoon, everyone. Audrey, I'm hoping that you can pull up my the PowerPoint. Great. So I'm going to talk about the Bar Exam Strategies and Stories program. If we go to the next screen. So just to give everybody an overview of what the initiative is, I want to start with talking about what it's not. So it's not a bar preparation course. So what it is, it's an approach for taking the bar exam. It's a mindset on how to approach your study. So test takers are encouraged to describe their experience with the bar exam, to write advice to future test takers, and they can do all of this at their own pace. This is an online, on-demand program that is fairly quick to complete. And what we know about this initiative so far is that the results from the first 2 years have been promising. This program increased the likelihood of participants passing the bar exam, and that ranged from anywhere between 6.8 and 9.6 percentage points when controlling for other factors. And the impact was even higher for applicants in disadvantaged groups, which includes those in underrepresented racial and ethnic populations, and those who are first-generation college students. We're planning on having a presentation at an upcoming CS Bars meeting, or Natalie, I believe it's at a law school assembly meeting, right? Where we're going to be covering some of this. Next slide, please. So just give you a background on the research team. The research team includes a team of law and psychology professors. They're led by Victor Quintanilla from Indiana University. He's a bicentennial professor of law, co-director of the Moore School of Law Center for Law and Society and Culture. Dr. Sam Ehrman, professor of law at the USC Gould School of Law, is a member of this team. Dr. Mary Murphy, Herman B. Wells Professor of Psychological and Brain Sciences, and Associate Vice Provost for Diversity and Inclusion at Indiana University. Dr. Greg Walton from Michael Foreman University Fellow in Undergraduate Education and Associate Professor of Psychology at Stanford is part of that team as well. What's being collected during this 15-minute sign-up period is information that is being provided to the research team. The State Bar, in terms of the data that's collected and what they have control over, is just information comparing who has signed up before we send out another reminder email. All of this information asks, it's general information about the applicant, and it's used strictly for contact information. And some of the questions we've received also include whether the bar will know whether someone's completed the program or see any part of this information involving the program. And as I mentioned, we'll know who's participated because when you haven't, we determine who's participated or registered because when you haven't, we'll send out a reminder email. If you've registered, then we will not follow up with you. However, and that's the only information that we get. Simply for this email blast for an administrative task, we do not see any information that's shared with the research team. We also were asked about whether there are a limited number of slots for participation in this program, and that is not the case. This does not have a limited number of slots for participation. Also, you'll see in the upcoming slides that there are different waves of signing up. And so the question's been raised, what happens if somebody misses one of the waves, wave one of the sign up? Can they participate during wave two? And the answer is yes. I'm going to talk about the distinction between each of the waves. Wave one is for people who would have registered for the bar exam, because that's how you register. As you're registering for the bar exam, that opportunity comes up within the application process. Once you've signed on, like I mentioned, we don't hear from that applicant in the bar exam strategies and stories program. If they have not signed on, we will send you reminder emails after. And these emails have been coming for wave one, because today wave one closes and wave two will open. If anybody in wave one misses that opportunity, they can still register during wave two. Wave two is targeting immediate repeaters. As you might know, May 7th is the date that we will be releasing bar exam results for the February 2021 exam. And our first invitation email for those that did not sign up during the registration process will be May 12th. And applicants will have through June 29th to register for this initiative. Applicants, again, can use the same link, whether it's you've got it during wave one or wave two. And as I mentioned, we're going to send through at least 3 reminders between that initial period and June 29th. Next slide, please. So again, the deadline is tonight for those that want to register for the program in May. And those that do register, the program itself will then launch the first initiative on, sorry, is there a next slide? Sorry, so applicants who've registered in the first wave, the program launches on May 20th. I thought I had put that in the instructions. So there is more information on the website on how to sign up during the bar exam application. And also the email itself that goes out to applicants will have a full set of instructions to applicants, to any examinee applicants that are participating in this program. All right, any questions?
I have a question, if I may.
All right.
I'm really very much interested in this program. You mentioned that there was a 9% increase. Was that in the aggregate of all applicants? How was that measured?
Yes, it's an aggregate of all applicants for that the cohort of examinees.
Do you have any data on how would have made a greater difference with any particular group? For example, graduates of ABA accredited schools versus California accredited schools versus unaccredited schools. You mentioned you have some data related to minorities or groups like that. But I just wonder if you have it related to schools.
I have not received the data in that format. As a matter of fact, it's been a while since we received a summary, a more comprehensive summary of the data, which is why we've made that request to Victor Quintanilla and the research group to come and present here to us. Because at this point, I think we've been, this is perhaps our fourth wave of participation. I shouldn't call it fourth wave. I don't want to confuse that with the stages of this, but the fourth iteration of this program initiative. So I think that would be something that we could pose to the researcher to perhaps provide a discussion on that level of analysis, and we can do that.
Well, I commend you on the program and encourage you to share with other states or the National Conference of Bar Examiners, because a 9% increase is not insignificant. It's actually very material and a very positive thing. And it's interesting to note that I gather you're just telling them, here's how we suggest you approach studying for and taking the exam itself. And surprising that it's taken this long for all of us to recognize that really can make a difference.
Yeah.
So bully for you.
Thank you.
Just a couple of thoughts before we leave this topic. The first one is, if you can encourage students to take it near the beginning of their program, that's very helpful, although it's helpful at any time. And then second of all, I'd just really like to thank the deans that by letting you know about this and share this with your students, it helps us to have you share things in the manner that is appropriate for your students, whether it's your student information system, text, or other ways that you might have available that we may not have in addition to the emails. So I thank everyone for those efforts.
Any other questions for Amy on the strategies topic? Thank you, Amy. I, like Greg, is very interested in whatever information can be presented at subsequent meeting about kind of the aggregated results. And I recognize that the numbers are growing, so the disaggregation will have more meaning the more times it's administered, but certainly being able to have access to that data, especially as it relates to particular students that we might be serving, would be incredibly helpful. So looking forward to more information as it becomes available.
Great.
Thank you.
Thank you.
So you're on mute again, Natalie.
Here we go again. Sorry about that.
It's my turn, I think.
We'll turn to our Assistant Director, Audrey Ching, to talk about a new initiative that we started this year in light of the pandemic, State Bar Day webinar for law students.
Okay. So I'm sharing my screen. So this was the title of my presentation for State Bar Day, which happened on Friday, April 9th, about resources, rights, and responsibilities for students pursuing licensure. I'm going to kind of recap the actual day, and then I know that you have a very meaty agenda, so I'm going to fly through some of the slides I did for the students, and if I'm flying too fast when I'm done, tell me to back it up, and I will. I just know that there's a lot to cover today, so I'm not going to go slowly through these slides as I might if I was, again, doing it for the students. But we had various state bar departments present to law students to showcase resources they can use and to go over all the different milestones and tasks they need to be aware of as they go through their pathway to licensure. We had admissions, so I presented, and David, Elaine, and Tara Clark from Moral Character presented. We had attorney records and consumer resources, which you just heard from in our presentations today. We had the Office of Chief Trial Counsel, and then the Lawyer Assistance Program went over all their resources for law students. We had students participating from 29 law schools, a total of 215 students actually in attendance. 23 of those law schools were ABA, 4 accredited, and 2 unaccredited. So good representation. We sent invitations to law school deans to forward to students and alumni. Thank you for forwarding those invitations on. We actually, the way the Zoom webinar kind of works is that there's a 500-person limit beyond the panelists. So all of those 500 slots were taken up in a week. As you can tell by the numbers I just showed, only 215 actually came. So food for thought for us for future, perhaps Zoom presentations about how to handle a wait list and letting more people in over time. But for the first time that we've done it in this way, it had a lot of interest and a pretty high attendance. So these are the slides that I presented to the students. And again, in being aware of your packed schedule, I'm going to go through this quickly. And I know you know a lot of these things about needing to register within your first 90 days. As you've heard from all of us, how important it is to update the contact information. So always stressing that to your students would be wonderful. Adding the domain calbar.ca.gov to a safe list. So all of our different unique emails that we send out from eligibility, admissions, moral character, testing accommodations that have this domain, making sure they go into the inbox and not into any other kind of folder in the student's email world. And when you're in your applicant portal, you're trying to log in and you can't remember your password, don't create a new account. So there's a forgot password link that I'll show in a second, or you can call to help reset your password. When students create a second account, then they have duplicate accounts and they may not get the information they need unless we on the back end merge their accounts. I went over the exams. Of course, you all know what our exams are, and we just went through bar strategies and stories. Just a tip for students, if you are not aware of this, sometimes students will go through their applications, not just the exam, but other applications we have, and leave it unintentionally in drafted or verified status and forget to hit submit. So always remember to hit submit and then double check in the portal that your applications are submitted. We've been doing post-exam surveys after each remote bar exam, so that means we've done 2. And after the February 21 exam, we had a much higher level of comfort from respondents. And these were just some of the highlights I shared with the students, that 86% of them agreed or strongly agreed that the materials provided by our office were timely. 76% agreed or strongly agreed that testing policies were clear. 70% were satisfied or extremely satisfied with the remote testing experience. 87% had no technical issues during the exam. And this is just an interesting one. 31% were testing outside of California. Obviously, that was never possible in our in-person bar exam. All the applications are on the portal, so making sure to familiarize yourself with that once they're in and registered. I was telling the students how important it is to understand the timelines. We post all the timelines and deadlines on our website. We also have multiple FAQs to read through, a lot related to obviously the remote exam, but we've put up provisional licensure FAQs, post-exam FAQs, lots of information on the website to go through if they need more information, making sure that their computers always meet those minimum system requirements for the online exam. And again, safe listing our domain, and then of course examsoft.com if they're sitting a remote exam. This is what it looks like when you go to that admissions page. When you first register, you create an account, and then I try to highlight this here that you can also click through if you forgot your password in lieu of starting another account, so you don't have multiple accounts under your name. When you log into your portal, this is what it looks like. It has some really bold dashboard icons here for the most popular things that students are doing on, or applicants are doing with the state bar admissions, like applying for different kinds of applications, putting in a general request. You can submit one here, or you can submit a request up here, and then making payments. So if you click through here on these top navigations, it's really easy to submit that general request and put through questions to our office to get answered by our staff. And then if you click to see where your applications are, like I mentioned before, this tab would say which things you've drafted, which ones are pending, either pending something that the student is missing or pending something that we are internally reviewing, which ones are approved, or I think it's handy to click on all here so you can not only see the status of your applications, but also where your general request is, if it's just been submitted or responded to or closed by staff. And again, these statuses read as approved. If it said something like drafted or verified, they'd want to make sure that until it's approved on their end, it says submitted. Reaching out to us through the website, through the general request that I went through. This is the main call center, resource center number, and making appointments to visit us in person now that that's more possible. And then of course, a lot of what we talk about is how to submit things online through the portal. We say that a lot, but for those who need it, we do have paper applications available. So just make it known that yes, if you need those paper applications, we do have them. And that was my express auctioneer style presentation. I know I went through it quickly, so if there's any questions about what I went through right now, please let me know.
Any questions from the committee? Audrey, just a quick question. I know that in the previous bar examination, you and I had an email exchange about the form that confirms that the student has signed off or the graduate has signed off on that they are affirming that they're taking it in compliance with all of the things. It wasn't at that time included in the list of documents that were approved or received, et cetera. Is that being added this time
Yeah,
around?
so
or is that still outside of that?
Thank you for bringing that up, because that's actually something I think is really good news, is that all of that information that we sent as external, like emailed documents out, is now folded into the exam application. So they go through all those testing conditions and affirm or ask if they would need to come in person, all of that during the application. So if they can see that they've submitted the application and appropriately, and then it gets approved, that means their testing conditions were also part of that. So because we had the Supreme Court remote exam declaration in advance of us putting out the application, we were able to fold that in ahead of time, which is a huge relief, I'm sure, for all the students, but really also for all of us, because that was difficult, and it's much better for the user experience and also just better for all of us that it's part of the application now.
Thank you, Audrey.
Thanks for mentioning it, because that's a real positive. So yay.
Okay, any other questions from the committee? All right. Okay, Natalie, any thing on recent developments that needs to be added?
I'll just double check with Amy or Audrey if there are any recent developments. Otherwise, we will have concluded our staff report.
No other updates.
Thank you.
Thank you, everyone. And now we're on to the next item on the agenda, which is a recommendation regarding the proposed amendments to the proposed revised rules for accredited law schools. Natalie, can you provide an overview and update of where we are in that process right now?
Yes, of course. So the accredited law school rules went to the Board of Trustees, who posted them for public comment, returning on February 15th. At the last committee meeting, the committee reviewed the public comment, but also staff proposed several slight nip and tuck amendments. It's actually quite common that after a large rule set is passed, that cleanup amendments, small things here or there, would be adjusted for clarity. And in this case, we became aware of them sooner and wanted to have them ready for everyone to see. So those are the ones that have been posted for a couple weeks now up on the website. If you wish, we can go through them. I have a red line copy available. The intention would be for the committee to review them again on Friday. They wanted to have a chance for CS bars to discuss, ask any questions and provide feedback. And they also wanted some time themselves to go through them. The thought is that these are not non-substantive and as a result likely would not need to go out to public comment. And I'll just touch base with Ken to see if there was anything that you would like to add in that regard related to these amendments.
No, I mean, I think that covered it well. If anybody has any questions, of course, we're happy to field them.
Okay, thank you. And if you'd like, we can place the red line up just to quickly go through them, or if you'd like to target us to particular ones. I know that the group has been reviewing them and sending questions over the last couple of weeks.
And just for clarification, did you receive any other public comment regarding the proposed amendments to the proposed rules?
No, we did not receive any external public comment.
Okay, great. So just to ask the committee right now, everyone has had a chance to review the document that was posted to the agenda. Are there any particular issues that people want to address specifically as it relates to the technical amendments?
Yeah, I have one.
Yeah, Marty.
So, sorry, I got so many windows going here now. 1 second, there we go.
And just, if you can name it, and Natalie, if we can put the red
Yeah.
line up so the public can see the item that Marty is referring to.
Yes.
Okay, so section 4.172A, it is on the bottom of page 21, at least of this PDF draft that I'm looking at.
Great. So let's just take a moment to get to that page. We are just about there, and you'll be able to see a red line of that change, what was there previously and what was proposed at the meeting. And it's very close to the end of the rule set.
I'm sorry, Marty, Dean Pritikin, could you please tell me which rule again? So I can
Yes,
put them up?
4.172A.
4.1.
There we go.
Okay.
Perfect.
And can, is this size good for everyone?
It's okay for me.
Okay, great, thank you.
All right, thank you. So to just give a little context, right, for those who, everybody. So, there's this whole section of rules on noncompliance and sanctions, the hearing procedure, et cetera. And so, 4.172 is the section that deals with probation, right? And basically it says if the committee finds such and such, right, that if you're not in substantial compliance or compliance as the case may be, but demonstrate an intent capacity to come into compliance, then they may place the school on probation for up to 2 years, right? And the insertion says, among other sanctions, the committee deems appropriate, which may seem like a technical kind of boilerplate, non-controversial provision. My only concern with this is that, in one of the earlier drafts of the rules, there was actually a whole section about interim monitoring, right? And the idea was we want to sort of have different levels, right, of sort of intensity or severity of sanctions. And so there was interim monitoring, which was sort of the lightest, most informal. There was probation, which was obviously short of full-blown termination. And the next step after probation was termination. So it was actually recommended that be taken out on the rationale that interim monitoring wasn't really a formal sanction. It was something that the staff has the authority, the inherent authority to do anyway. And because it wasn't a formal sanction, it wasn't the type of thing that required, public notice, publication on your website to students, prospective students, that sort of thing, right? So once that was taken out with that understanding, we were left with two possible sanctions. There's probation and there's termination. And so the concern I have, and I'm curious to see what others think or what the thinking was, for the drafter here, but when it says among other sanctions it deems appropriate, the question is, well, what could those be? What does that open up? Because it actually says later on in the section on termination, right, that termination is appropriate in situations where probation's not, right? Where they haven't come into compliance, don't show an intent or likelihood to come into compliance, or if there's exigent circumstances where it makes it inappropriate to impose probation and go straight to termination. So my question is, if we don't need to refer to interim monitoring because that's not a sanction, and we already have this very careful regime worked out where these are the parameters for probation, these are the parameters for termination, what does this phrase other sanctions refer to? And do we need to have provisions that would then proscribe or circumscribe the committee's authority or the procedures for imposing those other sanctions?
So Chair Gardina, might I provide some context?
Please do, Natalie. Thank you.
Okay, so coming back to the discussion, it's true, there was a point at which an interim monitoring condition was discussed, and some other accreditors do have that. Part of the reason that that was removed is that for the others that do, they are not necessarily public agencies, and often that interim monitoring step is a preventative step, or one that is done somewhat more in private. To try to prevent a problem or to prevent a problem from blossoming into something worse. Here, of course, we also have an incentive to prevent problems and try to do so generally, but we don't have that purpose because of the open meeting rules under which we operate. So that's why that was deleted. But at the same time, there are things that the committee does on a regular basis to help schools remain in compliance. Such as, for example, in a minor situation after an inspection indicating that they should update a particular document and then provide notice of that in their next annual report. So that's the sort of thing that's contemplated by this. Or there could be other situations in which a notice would be appropriate. It could be an appropriate step prior to probation, a notice going out to students or a notice going out to the public or the website. So that's what's intended here. And rather than have those things rise to the level of probation, which would be different than what's done today, the idea is to maintain that as something that could be handled short of probation to address things quickly when the school can respond quickly.
Well, Natalie, if I can follow up, I guess the question is a sanction a term of art in this context, right? Because if a sanction is something that requires public notice, then, or then it seems that there should be procedures attached to it. If report backs, which I wouldn't even think of as a sanction, right? I mean, I think, of course, if there's inherent authority to have interim monitoring, there's inherent authority to have a report back letter based on an inspection, right? So, I don't know if maybe we could have a guideline that specifies that nothing about this precludes the inherent authority of the committee or the staff to do these other things. But, if we're drawing this bright line rule between sanctions require X procedures, publication, due process, whatever, and other things that aren't sanctions don't, then I'm afraid this kind of opens up a wormhole in that regime.
And I don't believe that that's the intention at all. And also to piggyback off something that you said, whenever the committee requests these things, such as taking an action and reporting in the annual report, they are discussed at an open meeting. So they are something that is done in public, and the school has an opportunity to respond either through the inspection or through the response.
But is that a sanction?
Well, it sounds like there could be different interpretations, but that's what's meant here, just to indicate that that process would continue, and it absolutely could be clarified through a guideline.
Yeah, because obviously my concern, sorry, Greg, just one last thing. I mean, crazy hypothetical, right? I'm a law professor. Could the committee say, we're I think about like lawyers get sanctioned, right? We're fining you $10,000. Does that mean the committee could do that and there's no guidelines around their authority to do that? That's the type of thing I'm concerned about with this language. Sorry, Greg, I won't.
And I think that's the sort of thing that we could solve with a guideline.
Actually, may I be recognized to?
Yes, please. Thank you.
Actually, Marty, I think kind of raises an interesting thing I've been thinking about. I may have mentioned it when we were discussing these rules themselves, but probation. Well, this goes to Marty's point: is what is a sanction, what isn't a sanction? I'm not so sure that probation technically ought to be a sanction. It's a status, right? But the school that is approved but hasn't been removed from list or has had some kind of fine or something, but it hasn't suffered a sanction by putting on probation. Now, I recognize a lot of deans would say, boy, being put on probation is a sanction, but really it's a shot across the school's bow that we think you're out of compliance. You've got an opportunity to bring it in yourself into compliance, but you can continue to operate, right, until further action is taken. Now, I'm not suggesting we should go back through the rules right now to change that, particularly in the process, but I just offer for the committee's for future consideration. Some more thought should be given to what actually is a sanction, as opposed to something like inter monitoring and the report back that Marty was talking about, or like I say, probation, because I don't think probation is actually technically a sanction. It's a status. It doesn't feel good for a school and has real consequences, and maybe that's why you could argue that it should be considered a sanction. But I'm not. Probation is a corrective. It's a way to correct a problem. So we have a problem, and I think a school ought to be given an opportunity to say, well, we think you're not correct in putting us on probation, but I'm not sure it ought to be considered a sanction. But that may be for another day. But I think Barney's point is correct, that the committee and the board should be given consideration to that technical issue.
Thank you, Greg. Jessica?
I just wanted to, I think, agree with what Greg and Dean Predican is saying. It seems like already with a provisionally accredited school or a school that's on probation, there's already implied within that status, I think, that the committee has leverage to impose conditions or to require mandatory actions that would have the school, come out of its status. So while I don't think I have necessarily something to change sanctions to, I do think what is being said is a good point, that what I think is being attempted here might be a little bit broader, and it may be something that's already implied within the status of probation, because I don't think anyone would question here, just stepping back from it a bit, that the committee would have that leverage, that there are certain required actions or conditions that a school would have when they're under probation to come out of that status. So if what's being here is just another way to express that, then I think the language needs to conform to that more. But if there's truly something special and beyond that that's being added here, then I think clarity about what that is would be helpful.
Thank you, Jessica. Other members of the committee that want to provide a comment on this language? So one question, I'm sorry, Natalie?
I'll defer to Greg if he has a further comment.
Greg, your hand is still up. Is that because you have a comment?
Okay, I'll proceed. Two things. The first thing is I'll throw out there for consideration, does it feel better if sanctions is replaced by a word such as remedies or directives? That's my first thought. And then my second thought is I'm hearing concern amongst the schools that this would be used for a sanction of large magnitude. This is designed to clarify that it's meant for small magnitude, and lacking a phrase like this, it would advance those things that are now handled in an administrative manner through the public committee process into a probation. And so removing this might actually have the effect of finding schools on probation more often. And so I just wanted to have that clarification out there and hope that there is a way that we can use this phrase in conjunction with guidelines to be clear.
Thank you, Natalie. Marty, given that you were the one who originally raised it, Is there a motion that you'd like to make, or is this a clarification through a guideline?
I guess my motion would be to, well, here's a preliminary question. If I suggest changing any of this language, does that mean it's going to have to go through a whole nother round of public comment?
Depending upon the change that could be.
I mean, I would just want to change sanction to some other phrase like, among other, minor corrective action or something like that.
So corrective action, and I know Ken, and correct me if I'm wrong in terms of this, there's one option is to make a recommendation that the phrase be removed. We run into the issue that Natalie described in terms of potentially taking a tool of a lesser degree away from the CBE. Then there's the option of changing the word sanction to something else like action or directive, as is being recommended here. Taking the language out reverts us back, as I understand it, to the previous proposed rules, so it wouldn't in any way trigger a reboot, assuming the CBE were to accept it and move it forward with that phrase taken out. The other option is to change the language, and I'm wondering, just in terms of understanding what's deemed to be a substantive change that requires notice and comment versus not, does the OGC have a clear sense of what those kind of guide rails are?
So, I mean, I think in terms of subbing a couple of words for sanctions, I cannot imagine that in and of itself generating a recommendation that the board should send it for additional public comment. The entire addition of this phrase, per the OGC review, is not enough to recommend that the board send for additional public comment. So I think the bar is higher than a synonym change, certainly. Natalie was rightfully cautious in that, depending on, never say never, depending on what got plugged into there, but it doesn't sound like the conversation is veering in that direction.
All right, so I'm gonna make a motion then.
Well, may I make a comment before
the
motion? I think actually removing the red line, this additional language, which was, I can imagine why it was put in there, but don't we have language elsewhere in the proposed rules about the scope of the committee's ability to impose sanctions and a range of sanctions? I seem to recall that we do. And if that's the case, I think this is kind of superfluous. I mean, this rule 4.172 applies to probation only, I believe. And I think we have language elsewhere relating to other sanctions. Maybe I'm wrong. I mean, but I think if we were to take out this new language that's been proposed, then it certainly solves the problem, the issue I had before, and it may solve Marty's issue because we deal with sanctions elsewhere in the proposed rules.
Well, I don't think there is other language currently. What I was actually going to suggest, I mean, because, I would have initially recommended taking the whole language out, but in the interest of time, because I know we got a big topic to talk about, and to, move this along and hopefully satisfy the concern about depriving the committee of the ability to do lesser sanctions, what if we just insert the word lesser before sanctions? That way it's clear, right? The language better reflects the intent that it be more minor things short of probation, not something bigger or totally unrelated. So I would make a motion to amend that insertion to insert the word lesser before sanctions. And we could still clarify it more with guidelines, but I think that would at least alleviate the immediate concern.
So the motion on the floor is to make a recommendation to the CBE that the phrase in 4.172A reflects, among other lesser sanctions it deems appropriate. Is there a second for that motion?
Dean Gardina, can I for a moment just write up that motion and put it onto the shared screen so I have the exact verbiage documented?
And
But we don't need to do that if there's no second. So.
Oh.
I did want to, maybe move for just one point of further discussion. What Greg was mentioning, it's on the screen on number 3. When I scanned the document, the other mention of sanctions is above 4.172 item 3. I don't see another mention of sanctions there, but I do agree with Greg, if it is mentioned to the degree that it's covered somewhere else, then maybe we don't need the redundant language. I just want to make sure that was on radar for the group before continuing on with checking for the second motion. Thank you.
Thank you, Jessica. I appreciate you raising that.
And Jackie,
Yes, Greg.
thank you, Jess, for noting that. It was that close. That's my memory, and I would intend to oppose the motion, not because I'm opposed to sentiment, but I just think that we carefully reviewed all this, and we had this business on sanctions already addressed in the previous paragraph, subparagraph 3, and probation is a status, and school can continue to operate. That hasn't been fined. Restrictions haven't been put on it. It's a warning. Hey, if these issues that we've identified are not corrected, you may have to be removed or sanctions may be approved. So I think the proposed language should be stricken from the proposed rule.
Well, then I'll withdraw my motion and I'll propose that.
And propose what specifically?
Striking the red line in 4.172A.
Yeah, just take out the red line.
So the recommendation to the CBE, Marty withdrew his original motion, would be that 4.172A technical amendment, among other sanctions it deems appropriate, be removed. The reasoning being that the prior rule addresses other sanctions in terms of the CBE's power.
Right. And
okay.
probation is a status, it's not a sanction, technically.
And then do I have a second for that motion?
Second.
Okay, so any discussion?
I know I've been speaking up a lot and I don't want to take too much of the floor. I'm definitely more comfortable with having the existing language speak for itself. It's actually less confusing. I think if you revisit it somewhere else and it actually, it's not clear whether it means the same thing as the existing language or it truly means something else. The only question I had left was to the point that our staff raised, that if we remove this language, it somehow means that there's less leeway to give a law school, and I'm just going to look above, a sanction in lieu of putting them on probation. I think that was an interesting concern raised. I just want to check on that before voting.
So that is how this particular phrase was inserted. It was once looking at 3, making it clear. The original purpose was making it clear that the committee could, in line with number 3, choose something other than probation. So that's why it was inserted as a clarifying change. You may determine that you do not feel the same, but that was the intention.
And I just want to check, there's no other existing language that covers another option than probation at this stage. It would only be here that we could include language related to that.
The thought is that this is the appropriate place because it's clarifying that probation is not the only option. So that's why it belongs here in the probation area.
Okay.
Well,
go ahead. Sorry.
Well, I just, we went through a whole discussion before when we were talking about these rules about, the core requirement, right? The committee could impose a sanction even if there were not a violation of a core requirement, depending on the sanction and the appropriate nature of it. I just think adding this language, while well-intentioned, actually adds more confusion to the document and the rules. Under the proposed rule, the committee has the power to impose sanctions if the school is non-compliance or substantial compliance as applicable. Why do we need to add it again here as clarification? It's a clarification, I think, that adds confusion. Rule 4.172 deals with probation itself.
Thank you, Greg. And so we have a motion on the floor. Any discussion about the motion on the floor?
Sorry, I do have one more question. Is there any need, and Natalie, I think I'm directing this question to you, So if it's not sanctions, right, because I think that's what's causing confusion, is there a value to adding something to the probation section that goes to the effect of, I'm just thinking, among other remedial actions or some other category than sanctions? Is there a separate and an independent value to that? In 4.172, that is not sanctions, but it's something like among other lesser remedial actions. And I'm just doing this for the sake of exploring the pros and cons before voting. Yeah.
Yeah, I mean, thinking on the fly, my initial thought is that it probably could be the same. If you were to change it to other words like remedial action, I actually would have a little bit more concern about lesser, only because while it is intended to be lesser, I would not want to spend time just arguing what is more or
What
lesser
that means, maybe.
than
Yeah.
probation. But so remedial
Oh,
action is
sorry.
superior to lesser. It's remedial action.
So
Got it. Thank you.
thank you, Jessica, and thank you, Natalie. We have a motion on the floor that would be a recommendation from CS BARS regarding removing the language from 4.172. It would be a recommendation that would be presented as part of the conversation on Friday regarding this motion. So if there's no further discussion, why don't we actually have a vote on the motion?
But I have just one last
Oh,
comment, Jack. I don't want
apologize,
to
Greg.
gum up the works here, but I think providing some rationale for, if that's the committee's will, I don't know the voters are going to go that way, but for rationale ought to be that, look, you're adding language here that while well-intentioned is actually adding something to the rules that is not necessary. It's superfluous. Elsewhere in the rules, we have the committee has the power to impose sanctions after giving appropriate notice. And I don't think we should be putting that into the probation section. Probation, and I recommend a report, if we adopt it, should be adopted along those lines.
You'd like the recommendation to reflect the reasoning that the language
Yes.
is superfluous and that it is contained, that power and abilities contained in the prior rule. And so the motion would reflect the reasoning when it's presented to the CBE, assuming it passes.
Yeah, and the only other comment I make is I actually ran into this in the ABA, sort of these discussions too. So it's not like the issue has come up before in a different context, but it's the same sort of thing. What is probation really? It's an opportunity to correct a deficiency. It's not a sanction itself, technically under the rules. I acknowledge that the school would consider being put on probation as a bad thing, but in fact, it continues to operate and has an opportunity to address the issue. A sanction would be a fine or a restriction on ability to, offer degrees or something like that, or actually be removed from the approved list.
Thank you. Ashley, roll call vote.
Okay, first, can you please confirm that my language on the screen is currently correct?
Yes.
Thank you. Okay, Dean Clancy,
I abstain.
Dean Frickberg,
Aye.
Mr. Kramer, Mr. Kramer,
Aye.
Mr. Murphy,
Aye.
Dean Park,
I think I would abstain.
Dean Pritikin,
Aye.
Dean Gardina.
Aye.
The motion passes.
Thank you, everyone. Thank you, Marty, for raising the issue. So any other issues related to the rules before we move on to the NPR discussion? Okay. All right, so the NPR discussion, as we stated at the beginning, what we'll do is have a staff presentation about the options or what's being presented to the CBE. We'll open it up for public comment, limited to 2 minutes per person, and then we will have a committee discussion following that about any potential recommendations to the CBE about the NPR and guideline 12.1. Natalie?
Okay, so I'll ask Ashley to bring up the presentation in the folder. It's marked for CS BAR's discussion. And while she's bringing that up, I'll just catch everyone up on what's been happening so far related to the NPR. With the addition of an alternative pathway to licensure as part of the provisional license program, the committee was interested to know if it should be considered or discussed what should happen in light of the fact that now there was a program in place, though of temporary duration, that might discourage the taking of a bar exam for certain students, for certain graduates, because an alternate pathway was available. So the committee began a discussion back in its March meeting, discussing a few elements and wanting to continue the discussion after hearing from CS BARs and having a little bit more time to think about the first discussion. So we'll get started here with the presentation. We'll go on to the next page. And I've included Paul because Paul helped to craft the discussion that began at the committee and continues here today, talking about the NPR formula and possible amendments that could be proposed to the NPR formula. Most of you are well aware that the NPR formula is contained within a guideline, which is within the CBE purview to amend. Okay, next slide, please. I think you're also well aware of the calculation, but the calculation involves graduates within a particular 5-year period. So other people may be taking the bar exam, but the active calculation will include only those graduates who were graduating during that 5-year period. And currently, as it's written today, it looks at their bar results on the exams that happened during that same 5-year period, plus the February bar exam after that period, if in fact that was no more than 10 administrations after that individual's graduation. So as a practical matter, that means that the reporting period, those who graduated in the reporting period, March, in this case, March of 2016 or later, could also include their February results. Okay, and in this case, with the addition of the PLL, we think that some people who could enter the pathway may not have decided to take those February results. Okay, let's move on to the next slide, please. So this is the overall summary recommendation that is on the staff recommendation based on staff input, but also the discussion that's taken place so far at the Committee of Bar Examiners. Overall, to include the October 2020 bar exam in the 2021 NPR reporting period. And for each of these discussions, we'll talk about them more in the upcoming slide. To exclude from the NPR current participants in the alternative pathway. And then after they complete the pathway, if they're still within the reporting period for the NPR, to include them in the NPR numerator and denominator. If they exit the pathway without completing it, return them to the NPR denominator until they pass a bar exam. And normally, though you would just go through the reporting period, plus in some case the February results, as far as completing the pathway, it's proposed that that should continue through the July 1st reporting date to give a little bit more time for people to complete the pathway. Although what we're seeing is this pathway program just launched at the very end of February, and we actually already have our first completer that has completed all the requirements of the program. And Amy may know better, but either has just gone on or is about to go on to the motion. And then finally, regarding the temporary PLL program based on student graduation date, no change is proposed. So that's the overall package, but let's break it down into pieces because that's quite a number right there. And while I'm talking about this, if you'd like to stop and ask any questions or make any comments, be very welcome to do so. Okay, let's go on to the next slide. Okay, so this first one we think should be not very controversial. The committee quickly agreed regarding this. Normally, there is a July bar exam, and last year in July 2020, that did not happen for reasons of which we are well aware. Instead, the bar exam took place in October, which is technically outside of the reporting period. So the thought was to make it clear that those results, which were always expected to be part of the MPR, should in fact be included. And I'll just stop here for a moment to ask if there are any questions or concerns about this. Otherwise, I'll assume that this is a consensus. Okay, hearing none, I'll go on and let's move to the next slide. Okay, let's spend some time here for a while. Let's recap some of the discussion that took place at the CBE meeting. And in a moment, I will also ask for some input from our counsel, Ken Holloway. So before we get into the discussion, let's talk about some of the components of graduates. We received a letter in public comment from the CALS deans, and the position is a little bit different than what the committee has been discussing so far. So I wanted to define some groups, some of which are discussed here in the CBE proposal, other of which in the CALS public comment, just to make sure we're on the same page and we can have a great discussion listening to all the different options. So the first thing is thinking about the requirements in terms of Business and Professions Code 6060G. So all admittees are eventually required to satisfy the requirements of the licensing exam for the examining agency, in this case, the State Bar. Sometime earlier this year, the Supreme Court determined that the cut score for the exam would be dropped to 1390, effective with the July/October exam, but issued guidance indicating that that would not be applied retroactively. Sometime later, the provisional licensing program started, and that had an eligibility based on graduation date. So those who graduated between December 2019 and December 2020 were eligible to apply for a temporary provisional licensing program in which they could engage in supervised practice under the direction of a California attorney through the program end, which is June 1st, 2022. And to continue practicing law after that point, they would need to pass bar. So for purposes of identification, let's call those individuals graduation date provisionally licensed lawyers, or graduation date PLLs. So that's the first part of the program. The second part of the program began in late February. I'm going to call that pathway PLLs, pathway provisionally licensed lawyers. For those individuals, in order to be eligible for that program, they were required to have earned a 1390 at any phase of grading between the exams July 2015 through February of 2020. Now, already not all of that is in the reporting period. We talked about that earlier. So for purposes of the MPR calculation, we'll only be thinking about those pathway PLLs that are in this year's reporting period, or of course next year's reporting period. So there's our nomenclature that's going to start our discussion. We have a cut score, which is not retroactive. We have graduation date PLLs, and then we have pathway PLLs. Anybody have any questions about those discussions? I see one hand.
Yeah, Greg?
Yeah, well, it's a large issue, but I wonder how many people, even on this committee, or frankly, even the bar examiner board, understand the scale of the MPRE. It's on a 50 to 100 scale, which is entirely different than the MBE or the LSAT. And, you know, I have to say, I can't recall what your minimum passing score is on the MPRE, but there's a lot of ignorance out there about what the MPRE scale score means. So if your scale is 50 to 150 and the mean is 100, that's entirely different deal than on the MBE, where you have a 200-point scale and you know, a minimum passing score around the country is like 135, which is, or if it's the UBE 270. I think really people should pay attention to what the scores actually mean. The MPRE is more of a, have you been exposed to these rules and concepts kind of thing than, you know, have you achieved mastery of the rules? And I think it's an important distinction.
Thank you.
Thank you. Okay. So now we'll go on to our next step. So we've described our groups. Now let's talk about how they interact with 6060G, Business and Professions Code. And of course, Ken, feel free to jump in to add or enhance at any point. So it's long been true that those that pass outright, that receive the cut score required for each individual exam, satisfy that requirement. After the Pathway PLL program was created, at least one dean, but probably several, asked, in some cases directly to the Supreme Court, if that changed the prior guidance from the court, and if 1390 received any time after July 2015 going forward was considered a passing score. The court thought about it for a little while and responded with 9.49.1, which was an adjustment, a declaratory amendment, so not changing prior, but rather clarifying it, indicating that 1390 is not a retroactive passing score, but the bundle of requirements in the Pathway PLL program would be considered to satisfy that requirement. So therefore, when the committee continued its discussion, it focused on that definition. So those that earned 1390 during those periods had two options in order to go forward to practice. The one that they had always had, which is to take and pass another bar exam to satisfy 6060G, or alternatively, to choose this bundle of options described in 9.49. And I'll pause for a minute in case Ken has anything to add.
No, I think you're explaining it well, Natalie. And I think, as you mentioned, this was an amendment to 9.49.1. So I think a lot of conversation that began when the Pathway program started went in a lot of different directions. And I think for the purposes of the last CBE discussion, as Natalie noted, I think they looked to this for some real clarity as to a path where they could have some understanding of, you know, regardless of the fact that CBE sets in the guideline, you know, the NPR, that they could look to the spirit of what the Supreme Court was doing in terms of being able to be in line with that and have a real conversation and come to some consensus. So, you know, it really had the effect on that conversation of narrowing what were a lot of branching possibilities, I think.
Okay, thanks. So I'll point out that in the public comment from the Cal students in their letter, I don't presume to interpret, if I get it wrong, correct me, but they would like to consider those scoring 1390 but not entering the pathway. And so there might be a fundamental disagreement there. And so we can talk about that more. I'm sure we'll hear more about that soon. And what I would ask is that we get some comment on the proposal as it's currently being discussed by the committee, implementing it or any questions, as well as looking at any additional points of view that the schools might offer. Part of one way to think about this NPR calculation is that this is also a regulatory measure. The Cal's deans talk a little bit about it being a number that students can use to give an idea of how likely that school is to help them to achieve a passing score on the exam. Another way is a regulatory lens, which is how likely is it that the school will prepare the graduates to move forward in the opportunities to satisfy 6060G that are available. And so we can talk about it a little bit more. Okay, so That's a little bit of the background and a little bit of the idea where the two proposals might branch, and we can talk about both. Are there any questions? Oh, I see one. And Dean Gardino, would you like to be the stacker, or would you like me to recognize people when they raise their hand?
It would be helpful if you could recognize people, and for the committee, if you could raise your hand when you want to talk. And Jay, thank you for doing so.
Yes, thank you, because I don't see all of you at once in the presentation, and I certainly want to hear from anyone that would like to speak.
Thank you. First, I just want to make sure to say thank you to Natalie and staff. You know, what we're looking at, I think, is our mathematical version of the Gordian knot. We're trying to untie here without cutting through it as others would. And it is a very interesting dilemma of balancing regulation on one side, again, transparency and accuracy on the other side. You know, what is efficient versus what is accurate is always a difficulty. And again, I think what I think really is referred to as option 2 right now, at least from the staff. Option 2 is the one that was being put forward. I think is a fair option. In comparison to the CAL's letter, what they refer to within the group, and I'm part of the group, of course, is option 2. And I'd like to get the opinion on that, because these are two different option 2s. And I think really the only distinction is option 2 from the CAL's is trying to make sure there's consistency and fairness and accuracy between what the ABA institutions are promoting as pass versus what will the state bar and the CALs be regulated as a pass. So my only question is, has staff reviewed the ABA recommendation in this area?
Sure. Okay, Dean Frickberg, thank you. You actually provided a lead-in to my next portion. So the ABA is looking at this information too. The ABA uses a different measure. Their measure is called the ultimate pass rate, and that requires each individual class to achieve a pass rate of 75% or more within 2 years after graduation. So for example, this year, very recently, they provided their data for the class of 2018 with their bar results through July/October 2020. Next year, they'll be looking at the class of 2019. So a couple of things. So let's take those building blocks that we defined earlier. The first one, the graduation date PLLs. And in that case, if someone directly enters the pathway, then they'll be considered a non-taker. If they haven't taken any bar exam before, they just automatically go into the grad date PLL and begin supervised practice while they can. They're considered a non-taker, and that's consistent with the current NPR and the state bar proposal. If they decide to take a bar exam, then they'll be placed according to their results as either a passer or failure. And that's also part of this proposal that's being presented to the CBE. Then let's move to the pathway PLLs. And so for those, the ABA will recognize those individuals upon entry to the pathway. And upon entry, they will not be considered a passer, but rather they will be placed in a category along with others who are in a diploma privilege category, and they will stay in that category. Whether or not they exit the pathway, they'll stay in that category. Reason being, the thought is most will move through that pathway quickly and complete it, but also they've got a much shorter time frame, looking at just 2 years instead of 5. So that's very close to what the CBE proposal would include, but just not the same because it's a 2 years versus a 5 years. It's also a 75% versus a 40%. And I don't believe there's any move afoot to adjust the 40 or the 5-year time frame. Then finally, regarding the 1390s, those are not recognized by the Supreme Court, by the CBE proposal, or by the ABA proposal. So those that received a 1390 between July 2015 and February 2020, but they don't elect to take another bar exam, they would be continued to be classed as a person who had not passed, a denominator person essentially. If they don't choose to enter the pathway, then they will not be considered as a passer, and they will not be considered in that diploma privilege category for the ABA. So the staff proposal is consistent with what the ABA is doing, other than that one minor exception of those few that may come out of the pathway without completing it. Okay. When I read the letter from the CALs, some other suggestions were proposed. We had been in contact with the ABA, so we double checked with them before today. I'd like to recognize Mr. Kramer.
Natalie, you mentioned 2 years, but one of the proposals that's going to be before the committee is simply to remove the pathway participants who haven't yet completed it from the denominator. But because the pathway program ends in June of next year, for the 2022 MPR, if they don't come out of the pathway successfully by then, they will be back in the denominator unless they've fallen out of the reporting period at that time, right?
That's correct. So many numbers. It's actually that 2 years that I was speaking about applies to the ABA ultimate pass rate. They look at the results of a single class 2 years after graduation.
Okay, thanks.
Yeah, and we'll spend some more time talking about how this would fit into the calculation in a moment. Okay, so let's go on to the next slide. And so let's put this recommendation into practice now. So we've talked about the package of proposed recommendations. We've talked about our definitions. We've compared to the ABA, noticing that it's largely consistent with what the ABA is doing, except that there's not an interest to have just a 2-year pass rate here in California. And so now let's put this into practice. So the first thought is looking at those that are currently in the pathway, your pathway PLLs. For those, the committee talked about 2 options in March, and the more, I'll say the more generous option is the one that is being recommended. And that one is to exclude from the MPR anybody who is currently pursuing the pathway. So imagine it this way. Though they have taken a bar exam and they have not passed the bar exam, they have had the qualifications to enter the pathway PLL. So imagine that sort of as taking a bar exam of sorts, but having pending results. They're waiting to find out, they're trying to complete all the results of the pathway. And if they can, then they can proceed with their licensure if they want to. So during that time, rare is the person that would also try to take a bar exam at the same time, though they are eligible to do so if they want to. And I'm sure there will be someone who does that. But I imagine it won't be the more common. So just recognizing that people that might have been taking the bar exam would not do so while they're in the pathway, it seems appropriate to consider them a non-taker while they are pursuing. The committee discussed something that was a little bit narrower before, instead looking at only those who truly changed their behavior as a result of the pathway program being started. So the pathway program wasn't really considered until after the October bar exam was done. So in theory, it shouldn't have affected anybody's taking of a bar exam up till October because it wasn't contemplated, right? So one option would be to say, hey, who was taking the bar exam up through and including October? And then suddenly in February, they stopped. Maybe only those people should be excluded because those people seem to have changed their behavior in anticipation of this pathway program coming to pass. We thought just for clarity that it might be easier to have just a general exclusion. So if we go to the next slide, we'll just have a quick example of how that could work. And we'll be using the same fictitious school for our examples for all of them. So in the first one, imagine a law school in which there were 100 students who graduated during the reporting period. Let's imagine that 50 passed the bar exam outright using the cut score in place for the exam that they took and passed. Let's imagine that an additional 4 qualify for the pathway program. They earned a 1390 on an exam between February 2016 and February 2020. Those with a careful eye will notice that I said February 2016. I'm trying to include those in the reporting period. Okay. Let's say that of those 4, 3 of 4 entered the pathway program, 1 did not. And so this is the law school that we will use through all of our case examples. And we did it this way because it's got all of your various options amongst those 4. Okay, so for right now, if today were the reporting day for the 2021 MPR, then this particular school's MPR would be 50 over 97. Reason being, school had 50 outright passers. Their denominator would not be 100 because 3 of the 4 entered the pathway, and so they would be excluded during this time. Okay, all right, next slide. Okay, so let's assume that some begin to complete the pathway. In that case, anyone completing would be added back to the numerator and denominator. So let's go to the next slide. So in this case, we've got the same school, but now was 50 over 97, their new MPR 51 over 98, adding back that one individual who completed the pathway to both the numerator and denominator. Next slide, please. Now let's imagine another person in the pathway exits without completing for any reason. Perhaps their job terminates before they have the 300 hours. Perhaps they just don't want to do that. They want to go back and take a bar exam. So in that case, they would be added into the MPR denominator. So next slide, we'll look at that. So now they would be treated as any other typical student. They had taken a bar exam. They had not passed the bar exam. They would be placed in the denominator. And we see that denominator change. Okay, next slide. So in summary, let's imagine we get to the end of the period. And actually that first, no, actually let's flip by this one and let's talk it through. Let's go to the next slide. In terms of timing, we could have picked a number of dates, and we think that it makes sense, though it will be more challenging for staff, to be honest, to give the maximum amount of time to allow you to track alternative pathway completion. We think that some, and perhaps even many, will complete even this year, but certainly all will complete by next year. They must enter this pathway by May 31st, and they must complete all the elements by June 1st of 2022. But with that said, we're willing to take on the administrative challenge of giving everyone until July 1st so that you can have the most current MPR when reporting. Okay, next slide. Regarding those temporary PLLs, we plan to do pretty much what the ABA has proposed. If those temporary PLLs decide to go directly into practice, as a few of them have done, then they would be excluded as non-takers consistent with the current calculation. If they do take a bar exam, then they would be classified according to their results. And we see that the vast majority are taking a bar exam, and a large number have already taken 2. Okay, next. Next slide. Yeah. Okay. So I think that's where we'll stop here. This is consistent with a staff proposal for discussion on Friday. And Dean Gardino, would you like to turn to public comment?
Yes, given the amount of time that we have left in our meeting, why don't we turn to public comment? And again, public comment will be limited to 2 minutes, and then we'll move to committee discussion.
Dean Brandis.
Thanks, everybody. It's very nice to speak with you, with those of you who I haven't spoken to for some time. I look forward to the day when we're all back together in a place together. My comment is very simple, and I think it's extremely important that the approach taken not confuse the public. It would appear to me from the presentation just made that this approach diverges substantially from the ABA approach, and therefore the comparison would be impossible in the marketplace as a result of the approach being recommended, or what appears to be the approach being recommended. I believe I understand the ABA approach very clearly, And I think there's no comparison between the staff proposal and the ABA approach. So this will lead to a great deal of confusion in the marketplace that's just unnecessary and not productive. I would also add that I think 6061.7 requires us to be forthright and accurate. It is hinged upon the definition provided by the CBE, and so technically permissible, but once again, 6061.7 was a reaction to a marketplace need for comparable information. And what we're seeing when we diverge a definition intentionally and knowingly is just creating confusion that's unnecessary to create in the marketplace. So I'd urge the CS bars to take a very, very careful look at what the ABA is actually doing. Try to be sure that whatever recommendation goes forward to the Committee of Bar Examiners is consistent and not confusing to the public. Thanks.
Thank you, Greg. Other public comments? Okay, there doesn't appear to be any additional public comments, so I now want to open it up to committee discussion.
Sounds like that was our first public comment.
I'm happy to call on the committee members. Greg?
Well, I went through the whole process with the ABA. I was one of the prime movers on the adoption of the minimum passing rule rate. And there are multiple reasons for that. And I don't propose to discuss all that now, but I think it suffices to say that the adoption of the ABA minimum passing rate by the council over the opposition of the House of Delegates, I might add, was done because the old rules were more complex and led to more confusion and unfairness, and were actually ineffective in accomplishing the goals, which were to really improve bar passing rates and allow students some assurance that they attend an ABA school, reasonable assurance they would likely pass the bar examination. It seems to me that the 40% rate that has long been in effect in California, and which is not subject to change here, is, like Greg Brand has said during the public comment period, really a different animal and a different philosophy related to what we're doing with respect to the California accredited schools, which is, I perceive it as a sort of an outsider in that sense, is that it's really giving many people as possible an opportunity, even against all the odds. But there is some level at which we're not willing to go below, and that's that 40%. But I agree with Greg that this is entirely, it's a different philosophy, and there will be confusion in the marketplace, inevitable confusion.
Thank you, Greg. Marty?
Yeah, I mean, I was going to echo that. I mean, I know there might be certain technical reasons or maybe even policy reasons for, the staff proposal, but it seems to me for a whole host of reasons I don't want to go into just for time. I already have enough of our time before. We should just, I think, do what the ABA did. It's going to be the cleanest, the easiest, minimize confusion. I think it's hard to argue otherwise.
Thank you, Marty. Natalie, did your hand come up in a response? You're muted.
It did, actually. So one thing I wanted to clarify is that, in fact, what I described was the ABA proposal, and we confirmed that this morning, but what's discussed in the CAL's letter actually does not reflect the ABA's proposal. And so I think that may be confusing the discussion. And if we need to review the ABA's choices so that we have a good, clear decision, I'd be happy to do that. Maybe I could just summarize quickly. So 1390s are not recognized by the ABA proposal. Those entering the PLL pathway only, not the PLL grad, are recognized upon entry to the pathway. That's a slight difference versus the staff proposal. The PLLs are classed according to what their status is. So if they've never taken, they're a non-taker. If they have not passed, they are a failure. If they have passed according to the cut score for the exam that they took, then they are a passer. And we saw something different in the letter. So I just want to make sure we're talking about the ABA's choice.
What do you mean by recognized?
Yeah. Recognized in the sense that an individual who received a 1390 during the pathway qualifying period, so between July 2015 and February 2020, they are not placed in the numerator. They are not considered a passer, nor are they counted in the diploma privilege option either. They continue to be considered a failure. And only upon entry of the pathway do they enter not the ABA's pass category, but rather the ABA's diploma privilege count.
Okay, so they are included in the denominator and removed from the denominator when they enter the pathway.
Correct. Well, at that point, they are in the numerator and the denominator. They're considered a diploma privilege passer upon entering, and the ABA will be having a diploma privilege category that it reports, as well as an outright bar exam category. California does not plan to distinguish between those two, but the ABA will. In the aggregate, I don't believe they'll be identifying individuals.
Okay, so then the difference between the staff proposal is that upon entry into the pathway, they would go into the numerator and the denominator, or just into the denominator. They'd be removed from the denominator, and the ABA plan is to, upon entry into the pathway, add them both to the numerator and the denominator. Is that right?
Yes, that's correct. So the difference is in the ABA proposal, they're recognized at the point of entry. In the staff proposal, the CBE discussion, they're recognized at the point of completion.
In the numerator.
Correct. And the ABA has two numerators. They'll be recognized in the diploma privilege numerator. The CBE staff proposal has one numerator.
Jack, I read good say I have to leave the meeting.
Thank you, Greg. Jessica?
So I think I definitely have some concerns, and then I want to follow up with a question. I think it's very important for what we decide on that it is trying to, I know the illustration given was, right, someone who obviously is not going to be skirting around the 40 in terms of, for their own institution or what they're representing in mandatory disclosures to students. But I definitely have that concern sort of in two ways, that the explanation that has to be given for law schools to do this mandatory calculation has to be clear enough that it's serving the value of that public transparency and disclosure. And so I have some concern with, multiple points of revisiting the number. I think in general across the recommendations, anything that sort of can revisit that number a fewer number of times might just be easier to explain, or to make sure that that task of giving a public disclosure to a student is clear. Because I think if the school internally or the student externally is trying to figure out what they need to from the information, it's going to be important that they understand why it's shifting at the different points. I raise that just as a concern, really to lead to some questions, because this is really going towards what's going to have to be mandatory, right, for the schools to calculate the Cal accredited schools. So in terms of logistics, right, with the ABA, it sounds like they would have those two different categories, one for the diploma privilege passer and one for the normal bar exam passer. And I imagine systematically the information that's being given law schools to calculate that information so that it's accurate and, you know, everyone's on the same page has to be delivered in some way. So my question is just for what is being contemplated, what information is going to be given to law schools to make sure they know, you know, they're on the same page with the state bar about the numbers to calculate one way or another. I think especially because there's the whole time cycle that, so the difference between the ABA and the CB staff proposal is, you know, upon entry with one and upon completion with the other. What's going to be the internal information distribution to make sure law schools know either way, right? You can count these people because of them being upon entry or upon completion, because the law schools don't access Ames, and I don't think they necessarily need to, but they're going to definitely need to rely on some sort of central information distributor to be able to say to the public, or to their own stakeholders, that they're calculating it accurately. So that's my question. It goes more to logistics, but
just I know that we have 5 minutes left in
sorry.
our noticed meeting, and I am sensitive to that. So Natalie, can you just say quickly, yes, the information will be provided, or we're working on how that's going to be delivered, or good God, we never thought of that? You're muted.
You're muted now.
Yes, the information that you will need to calculate the figure will be provided based on what the committee decides. Yes.
Thank you.
Relative to the formula that the committee says.
Right. So Marty, I see that your hand's up.
Yeah, so I had seen what was circulated to the ABA schools about how they're calculating this. My understanding was this isn't related to the diploma privilege category, because if it was, there wouldn't be an issue of upon entry, right? The pure diploma privileges, you're just admitted, right? So this mechanism for calculating for provisional licensure really does relate to what they consider bar passers, not diploma privilege. So I don't think we're going to get clarity in the next 4 minutes about what it actually is, right?
Well, we should, I know we have just a few minutes, but we did actually share the proposal with the ABA. So we do have that clarity. So the response does reflect that clarity.
So is there something that can be circulated to us about that?
Let me see if we can get something, yes.
Okay, so what I'm going to do, since we only have 3 minutes left, since my understanding prior to the last 60 seconds was that option 2 in that memo did fairly reflect what the ABA's proposal was, and I do think it's important to try and have consistency with the ABA, I'm going to make a motion that CS bars recommend to the CBE the adoption of Cal's memo option 2. And if someone needs me on the record to say more than that, I don't know that I'm able to on the fly, but that's what I would propose, is the CS bars recommend to the CBE the adoption implementation of Cal's memo option 2. We can take the next 48 hours or less to try and figure out what is that the ABA or not. But if we want to have something concrete to propose to the CBE by Friday, that's what I would move.
I second that motion.
All right, so we have a motion which is to adopt what is identified as option 2 in the public comment provided by the CALS deans. We have a second on that motion. Is there any discussion? All right. So seeing none, Ashley, can we provide a roll call vote?
Yes, can you help me just so I can make sure that I accurately capture this? I know that we only have a few moments.
Yep, second, option 2 provided. Yep. Option 2 provided in the public comment from CALS.
Can I suggest you eliminate the word second?
Yes, thank you.
Okay, so I've accurately captured that. Excellent. Moving on to the roll call vote. Dean Clancy.
Aye.
Dean Kirkberg.
Aye.
Mr. Kramer.
Abstain.
Mr. Murphy. Oh, Dean Park.
sorry to do this just real quick. I know that Marty captured there that we're willing to have a check be done. So with that being considered, I would be aye, because I would want to make sure that is accurate.
Do I need to make a modification to the motion as written on screen?
Maybe just say subject to check with ABA. Not to say that's not been done, but that
It's Marty's motion. So Marty, is that a friendly amendment, or is that something that you want to?
you may be able to say it
I
better.
would reject the friendly amendment because I'm afraid it's going to create confusion. My understanding and the base for the motion was that I think it is consistent with the ABA. If we find out it's not, either the CBE may reject it, fine. But as of right now, I would just leave it as is.
Okay, that helped. I would go aye with that.
Dean Pritikin,
Aye.
Dean Gardina.
Aye.
The motion passes.
Thank you, Ashley. I appreciate everyone's focus on this issue. The time that we spent on the rules as well, I think was well spent. Obviously, the Committee of Bar Examiners will be taking up both the rules as well as this issue at their Friday meeting. Certainly appreciate or encourage everyone on the committee in their capacity to offer public comment as part of that as well as members of the public. So appreciate everyone's time and attention here. Do I have a motion to adjourn?
Before you do that, Jackie, does everyone understand that you will likely be expected to make any public comments at the absolute beginning of the meeting?
Thank you, Paul, for that clarification. Yeah, so everyone would know that they need to be there right at the start of the meeting to offer public comment on anything on the agenda. Thank you. Motion to adjourn?
I'll move to adjourn.
Any opposition? Okay. Thank you, everyone. I appreciate your time today.
Thanks.
Thank
Thank
you.
you, everyone.